Okay. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Welcome to the joint class series held by Faculty of Law, Universitas Brawijaya, in collaboration with University Kebangsaan Malaysia, UKM. Today, 7 December 2020, this joint class entitled On International Human Rights Law. Let me introduce myself. My name is Mega Novita, and today I will be your master of ceremony in joint class. We really appreciate everyone involved in this joint class. The honorable distinguished guests and speakers, they are Professor Dr. Nazura Abdul Manap, Dean of the Faculty of Law, University Kebangsaan Malaysia, Dr. Muhammad Ali Safaat, Dean of the Faculty of Law, Universitas Brawijaya, Associate Professor Dr. Syahrul Mizan Ismail, Deputy Dean of the Faculty of Law, University Kebangsaan Malaysia, Associate Professor Dr. Rizal Rahman from the Malaysian and Comparative Law Center, Faculty of Law, University Kebangsaan Malaysia, Associate Professor Dr. Rohaida Nurdin, Law Professor at the University Kebangsaan Malaysia, Dr. Siti Nur Afizah Azizan, Senior Law Lecturer and Project Coordinator of the Faculty of Law, University Kebangsaan Malaysia, and Ms. Afifah Kusumadara, SHLLM, SJD, Senior Law Lecturer at Universitas Brawijaya, Ms. Ika Ningtyas, SHLLM, Law Lecturer at Universitas Brawijaya, Ms. Francisca Ayulistia, SHLLM, Law Lecturer at Universitas Brawijaya, and also the Chairwoman, Dr. Rika Kurniati, SHMA. Thank you very much for sparing your time in your very extremely busy time. And I would like to thank all participants who has joined today. Thank you very much for always supporting us. Thank you very much for your cooperation. Hopefully, this joint class can run smoothly until the end. The Faculty of Law, Universitas Brawijaya, and University Kebangsaan Malaysia have established academic cooperation through several MOUs. The latest MOU was signed in August 2019. This joint class program is one of the academic activities held to implement the MOU and to foster further collaboration between the two institutions. Besides that, this joint class program is expected to broaden the knowledge of the law students in both universities and to enrich them with different legal perspective, different legal culture, and different legal history. Before we start, I will explain the rule that needs to be followed by all of the participants. You are advised to mute your microphone to reduce the background noise, but basically the host will automatically mute them. We recommend you to turn on your camera because in the end we will have photo session. Firstly, the speakers will share each of their presentation and then just followed by the Q&A session after finishing the talk. In the Q&A sessions, participants can ask by writing the questions in the chat room, in Zoom, or in YouTube, or ask directly by using the raise hand option. Then our team will unmute your microphone. You can deliver the questions in both English or Bahasa Indonesia, but just keep it simple. After the speakers finish their talk, our team will send a link for attendance form in the chat room. The certificate of participation will be generated automatically from this attendance form. It will be sent to your email address. So please make sure you write your name and your email address correctly. We also provide the YouTube live streaming. So please check the link sent in the chat room. We request your cooperation to focus on the speakers while they give their talk. Everyone, let me preview the today's program. First is registration and preparation. Second is the opening ceremony by the Dean of the Faculty of Law, University Kebangsaan Malaysia, Professor Dr. Nazura Abdul Manap, and also the Dean of Faculty of Law, Universitas Brawijaya, Bapak Dr. Muhammad Ali Safaat. And third is lecturer, which will be led by our moderator, Ibu Nanda Saraswati, SHMH. And there will be three speakers. Associate Professor Rohaida Nurdin from University Kebangsaan Malaysia, and Ika Ningtyas SHLLM, also Ibu Francisca Aliulistia SHLLM. They are lecturers from Universitas Brawijaya. Then after the lecture session, we will have photo session and closing. Okay, everyone, we will start this joint class by listening the opening speeches. First, I would like to invite the Dean of Faculty of Law, University Kebangsaan Malaysia. Everyone, let's welcome Professor Dr. Nazura Abdul Manap. Ibu Professor Dr. Nazura Abdul Manap, the time is yours.
Thank you, Madam Chairperson. Can you hear? Thank you.
Yes, I can hear you.
Good, very good. Okay. Honorable Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Universitas Brawijaya, the respectable Dr. Rika Kurniati, the head of the organizing committee at the Brawijaya Law Faculty, and Dr. Afifah Kusumadara, the head of Research and Cooperation Unit at the Brawijaya Law Faculty, and the esteemed teams from Fakulti Undang-Undang UKM yang dikasihi Dr. Siti Rafiza Azizan and Madam Nazira Kamaruzaman, the MOU coordinators between UKM and Brawijaya University, Associate Professor Dr. Muhammad Rizal Abdul Rahman, the chairman of Malaysian and Comparative Law Centre, MICOL, and all the participants. Assalamualaikum warahmatullahi wabarakatuh dan selamat sore. It is my pleasure to be here with all of you today to extend my introductory remarks for the very first time with our counterparts from Brawijaya University, Malang, Indonesia. Thus, I would like to express my gratitude to Dr. Muhammad Ali Safaat, the Dean of the Faculty of Law, Brawijaya University, for organizing the online joint class program together with the Faculty of Law, University Kebangsaan Malaysia. I believe this useful program would not materialize without the never-ending effort from the program secretariat in Brawijaya and UKM. My deepest appreciation goes to Dr. Afifah Kusumadara as the International Partnership Coordinator from Faculty of Law, Brawijaya University, and the team from UKM, Dr. Siti Norafiza Azizan and Madam Nazira Kamaruzaman, as well as Associate Professor Dr. Muhammad Rizal Abdul Rahman, for their joint effort in ensuring the smooth running and success of this program. Without their outstanding endeavor and diligence, this program would not have been scheduled in this well-structured manner. Shower of roses to all lecturers who have agreed to share their expertise in this program. As a matter of fact, recently there was a similar program carried out by the Department of Criminal Law in Brawijaya University, namely 3-in-1 program, whereby as the visiting professor in your faculty, I have successfully delivered 5 lectures relating to criminal law between 27 October until 4th November 2020. Among other topics that have been shared with the fellow students are criminal law in the Malaysian legal system, cybercrime, cyber terrorism, sexual offences, and digital evidence in Malaysia. I was so impressed with the amazing responses by the students and the lecturers who attended the series of lectures. And I am so glad that the program secretariat has pursued with same initiative of this knowledge sharing. Despite the limitation due to the COVID-19 pandemic, we have proven that the delivery of knowledge is not entirely affected. With the advancements of technology, it is now possible to do something that could not be done in the past. With the help of technology, these noble initiatives are proceeded mainly to share the expertise and convey beneficial messages. The online joint class program is meant to gather participants, lecturers, and students alike from both institutions and consists of lectures and discussions about laws in Malaysia and Indonesia. I strongly believe that the merger of knowledge among lecturers from both institutions will lead to more benefits in the future, perhaps in the form of research and publication collaboration. As for the students, it opens up their mind in understanding the comparative approach of both countries, namely Indonesia and Malaysia. From the poster shared, I discovered that there are three different themes involved in this program that are international women rights law, federalism and national legal system, as well as private international law. We have on UKM side our expert in the respective fields. Associate Professor Dr. Rohaida Nordin in International Human Rights Law, Dr. Hafila in Federalism and National Legal System, and last but not least, Dr. Helmi on Private International Law. And I can see the team from UKM have been partnered with the experts in the field from your end, which are Madam Ikaning Tias, Madam Francisca Ayustia, Madam Prisca Lee Tiningsgram, Mr. Shahrul Sajidin, and Dr. Afifah Kusumadara. I wish you all the best in your lectures and hope the students will benefit so much from this sharing of knowledge. Again, I would like to thank you to everyone who has assisted to ensure the success of this program. I strongly hope that we shall continue our joint venture for many years to come for the benefit of both institutions. I will end my speech with dua rangkap pantun. Parang tajam tidak berhulu, buat menetak si pokok ru. Bila belajar tekun selalu, jangan ingkar nasihat guru. Ramai orang membeli jamu, di bawah pokok cuaca redu. Bersungguh-sungguh mencari ilmu. Ilmu dicari, penyuluh hidup. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. And thank you.
Waalaikumsalam warahmatullahi wabarakatuh. Okay, Ibu Professor Dr. Nazura Abdul Manap, thank you very much for your speech and for the pantun as well. Okay, everyone. Next, I would like to invite the Dean of Faculty of Law, Universitas Brawijaya, to deliver the welcoming speech. Bapak Dr. Muhammad Ali Safaat, are you ready? Are you connected to Zoom right now?
Yeah.
Okay. Okay, everyone, let's welcome Dr. Muhammad Ali Safaat. Time is yours.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Honorable Dean of Faculty of Law, Universiti Kebangsaan Malaysia, Professor Dr. Nazura Abdul Manap, Honorable Dean di Faculty of Law, Universiti Kebangsaan Malaysia, Associate Professor Dr. Shahrul dan Ismail, distinguished teachers and colleges from both University Bangsa Malaysia and Universitas Brawijaya, all students from Brawijaya and UKM. Alhamdulillah, thank Almighty God for the abundance of help to all of us. And I'm very pleased to be here, colleagues both from UB and UKM. The cooperation between Universitas Brawijaya and Universiti Kebangsaan Malaysia, especially between law faculties, has been going on for quite a long time. And we would like to thank to the Faculty of Law, Universiti Kebangsaan Malaysia, which has been willing to organize various forms of activities together with the Faculty of Law, Universitas Brawijaya. We believe this cooperation will benefit our institution. And the field of law, a comparative study between Indonesia and Malaysia is certainly very interesting. We are next door neighbors, which definitely influence each other. We also come from the same cultural root. However, we have different legal system and we do hope that the joint class activity can broaden horizon, especially for students. Hopefully, this activity in the future can be carried out physically in UKM and UP so that students not only gain knowledge but also feel the academic atmosphere and social culture in Indonesia and Malaysia. And also, I'm very thankful for the pantun, and I'm so sorry because I'm thinking hard for the 3 minutes how to reply, but I not get the right pantun. So thank you very much for the pantun. Sorry and replay it. And this is my welcoming speech. Again, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you Bapak Dr. Muhammad Ali Safaat. Before you leave and also Professor Dr. Nazura leave, I would like to request for taking photos together. So please all the participants can turn on the camera so that we can have a good picture. Yeah, here we have 362 participants. So there are 15 screens. So I will request the operator to take snapshot for each of the screen. So the first screen, Ibu Rizka, Ibu Sri, Ibu Evangeline, Bu Fariza, Bu Rais, Bu Magfira. You can turn on your camera first. We still have many participants here still turn off their camera. Okay. Okay. The first screen, you can say cheese or say hi to the camera so that you can lose your tense. Thank you. First screen, second screen. Okay. Okay, I think it's enough. Thank you very much once again for Professor Dr. Nazura and Bapak Dr. Muhammad Ali Safaat. If you have any schedule, the following schedule, you can leave this meeting. But if you want to join this joint class, so it's also welcome. Everyone, we are now about to start to the main agenda, which is the presentation from our great speakers. Our moderator, Ibu Nanda, will lead the session. But before she starts, let me introduce Ibu Nanda. She is a lecturer in International Law Department, Faculty of Law, Universitas Brawijaya. She finished her bachelor degree of law, majoring international law in Faculty of Law, Universitas Brawijaya on 2009, and master degree of law, majoring transnational law in Faculty of Law, University of Indonesia on 2012. She has published many articles in national and international journals. She also actively joins the conference abroad. Okay, Ibu Nanda, are you ready for the plenary talk? Ibu Nanda,
Yes.
are you connected here? Okay. Ibu Nanda, time is yours.
Okay, thank you so much, Ibu Mega, for the warm introduction. Can you hear me?
Yeah, I can hear you.
Okay. Hello, everyone. Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, selamat petang. Good afternoon, ladies and gentlemen, colleagues and students from the Universiti Kebangsaan Malaysia, colleagues and students from the Faculty of Law Universitas Brawijaya, and to all participants. Greetings from Malang, Indonesia. On this good opportunity, please allow me to moderate this first day session of the joint class between Universitas Kebangsaan Malaysia and Universitas Brawijaya entitled International Human Rights Law. This joint class will be delivered by 3 wonderful lecturers. The first lecturer is Associate Professor Rohaida Nurdin from the University Kebangsaan Malaysia. Professor Rohaida is a senior lecturer at the University Kebangsaan Malaysia. She holds a Bachelor's of Law from the University Malaya, Malaysia, Master's of Law from University Kebangsaan Malaysia, and a PhD from Lancaster University, United Kingdom. Her research areas or specializations are related to international human rights law, specifically on asylum seekers, refugee, women, children, and indigenous people. She currently teaches courses such as criminal procedure and also advanced international law. She is also attached to the Center of International Law and SIAR, SILAS, in the University Kebangsaan Malaysia. Today, Professor Rohaida will deliver a lecture on substantive international human rights provisions, scope, and application. The second lecturer is Ibu Ikaning Tias, SHLLM. Ibu Ikaning Tias is a lecturer here at the Faculty of Law, Universitas Brawijaya, under the Department of International Law. She holds a bachelor's degree from the Faculty of Law, Universitas Brawijaya, and a master's of law from University Kebangsaan Malaysia. Currently, she teaches areas of human rights and also humanitarian law. She is currently also continuing her PhD studies at the Faculty of Law, Universitas Brawijaya. The last lecturer, but surely not the least, is Ibu Francisca Ayulistia, SHLLM. She is also a lecturer here at the Faculty of Law, Universitas Brawijaya. She holds a bachelor's degree from the Faculty of Law, Universitas Brawijaya, and master's majoring international humanitarian law and human rights from Geneva University, Switzerland. Her research area is on humanitarian aid and rights of minorities. So today, Ibu Ikaning Tias and Ibu Francisca will deliver a lecture on the relation between international human rights law and international humanitarian law. So ladies and gentlemen, and all participants of today's joint class, to begin our joint class today, I will give Professor Haida first approximately 25 minutes to give a lecture, and it will be continued or followed by Ibu Ikaning Tias and Ibu Francisca, who together will deliver a lecture for also 25 minutes. And afterward, there will be a Q&A session. So for all participants who wish to ask a questions or give any comments, please kindly write down it on the chat box stating your name, institution, question, and to who the question is addressed for. So before we start, I kindly again ask all participants to mute their audio so the lectures can run smoothly. So without further ado, I will now give the time and screen to Professor Rohaida. Thank you.
Thank you, Ms. Nanda, Madam Moderator. Bismillahirrahmanirrahim. Assalamualaikum. Good afternoon and salam sore. Yeah. Ladies and gentlemen, colleague and student. Yeah. My lecture today entitled The Substantive International Human Rights Protection, Scope and Application. Let me share my slide with everyone. Yeah. Okay, can everybody see my slide?
Yes, we can.
And hear me clearly?
Yes, we can hear you, Professor.
So thank you so much, Ms. Nanda. This area, my residential area is having a very heavy rain with thunder and lightning. So I am praying very hard for God to give me stable internet connection. Inshallah, please bear with me. Yeah. All right. So let's move on. My lecture, as I mentioned to you, entitled Substantive Human Rights Protection, Scope and Application. But for purposes of today's lecture, due to the time constraint, I decided to focus on only two protection, yeah? Freedom from torture and right to seek asylum. As you all may know that UDHR 1948 recognizes 30 rights altogether, but I won't be able to cover all 30 rights. So my focus of the lecture today will be on freedom from torture and also right to seek asylum. So let me start by explaining why this two topic has been chosen by me. Yeah. So as you can see, freedom from torture, probably you can see from the statistic here. From Indonesian side, there is a rising incident of allegation of torture inflicted by the state authority and the rise number of the custodial death, yeah, in the country. In Malaysia, the 2005 until 2015, there were 156 custodial deaths that reported in Malaysia, right? And why do I pick right to seek asylum as the scope for today's lecture? Yeah, because Malaysia and Indonesia, we receive quite a high number of asylum seekers and refugees. Okay, let me cite. According to the UNHCR statistic in 2016, yeah, the registered asylum seekers and refugees in Indonesia total up to 439, yeah, 439, and they all from Myanmar. Yeah? But if you compare that number to the number of registered asylum seekers and also refugees in Malaysia, ours is total up to 20,378 of them, and out of that number, 20,000 of them come from Myanmar. Yeah, and to conclude, and universally accepted human rights, but yet, yeah, most violated human rights, yeah, in Malaysia or probably in Indonesia. Let's move on. Okay, this slide reflects one instrument, which is Universal Declaration of Human Rights, and 9 core human rights treaty. Yeah, 9 core human rights treaties. It's all listed down. So I'm not gonna read them one to one to you. Okay, but I wish to highlight two things. Yeah. So when you look at UDHR, yeah, the legal status according to the international law is that UDHR is a General Assembly resolution. So it's declaratory of principle, yeah, broadly accepted within international community, and they has no legal binding effect on the members of the United Nations unless they become customary international law. And how about these 9 treaties that I listed down here? So obviously they are treaties, they fall under the definition of treaties under the Vienna Convention on the Law of Treaties of 1969, yeah, and their legal status is binding upon state who accede or ratify them. Okay, let's move on and see what is the performance of Indonesia and Malaysia with regards to the ratification of the 9 core human rights treaties. And obviously, if you look at this slide, yeah, Indonesia is doing better than Malaysia. Yeah, so Indonesia ratified and acceded to 8 out of 9 human rights core human rights treaties. And how about Malaysia? Malaysia only acceded 2 and ratified 1. Yeah? So altogether 3. So let me also highlight that, bring your attention, ladies and gentlemen, to Article 26 of the Vienna Convention on the Law of Treaties again. Yeah? Article 26 provides that one state ratified treaties, and if the treaty already entered into force, the treaty will bind the state party, and the state party has obligation to perform with good faith. Yeah, so this is the principle of Pansant Savendra, yeah. And the other relevant provision would be Article 34 of the Vienna Convention, which provide that treaty will not bind the state. So if you were to read, yeah, Article 26 and 34 together, what can you conclude from this table is that Malaysia only has legal obligation towards 3 treaties, whereas not to the other 6 treaties, and Indonesia has a legal binding obligation towards 8 treaties as a state party and not towards 1 treaty, which is International Convention on the the protection of people against enforced disappearance. So let's move on. So the first protection is freedom from torture. I would like to try and cover this 6 aspect of the discussion on right to torture. And I will start with the sources of protection for freedom against torture. So you can see here, I listed down 3 instruments. Yeah. So you can see there's an evolution on the sources of the protection for freedom against torture. It started off in 1948 by UDHR, Article 5, yeah, and transformed into a treaty, ICCPR, Covenant on Civil and Political Rights, through Article 7 and 10 in 1966. And in 1984, international community decided that they are ready to have a dedicated and holistic treaty on freedom against torture. And if you look at Article 5, yeah, it provides that no one shall be subjected to torture or criminal or cruel, inhuman, degrading treatment or punishment. I call it CIDTP, right? And Article 5 of UDHR is very material with Article 7 of ICCPR, while Article 10 of ICCPR provides that all people who deprive of liberty shall be treated with humanity and with respect for the inherent human dignity, right? And Article 1 and Article 2 of CAT also provide on the protection against torture. All right, let's move on. What is torture? Yeah, I have done you a big favor here by, writing the whole and verbatim the definition of torture according to Article 1 of CAT. Yeah, but for purposes of the lecture today, I have identified the element for torture, a torture declaration in 1975. Yeah, Article 1, 2. Yeah, it defined torture as the pain and suffering that should be an aggravated and deliberated form of CIDTP. So what does it mean? It means that, yeah, the aggravated, the extreme level of CIDTP will be tantamount to torture, whereas the lesser form of CIDTP will remain as CIDTP, right? So let's look at Article 1 CAT. Yeah, these 6 that I listed here, they are element to torture according to Article 1 of CAT. There must be an act that inflicting severe pain and suffering, yeah, which is different than cruel, inhuman, degrading treatment or punishment. And the act of a torturous act must be done with intention. There must be a mens rea there by the perpetrator. Torture can be either physical or mental, yeah. And the perpetrator must be among state officials, right? And the purpose of committing the torturous act is to obtain information or confession or punishing an act or intimidating. And there's a clause in Article 1 that excludes certain acts from torture. They are torturous acts, but inflicted due to lawful sanctions. So they will not be considered as torture. But if you were to compare Article 1 CAT with Article 721 of the Rome Statute, which is the statute for the establishment of ICC, yeah, the provision doesn't stipulate the purpose and the status of the perpetrator. So the definition in Rome Statute is more liberal, yeah. And in CAT as well, you will find a provision which is Article 16, which provide that cruel, inhuman, degrading treatment or punishment is not tantamount to torture under Article 1, although that it may be inflicted by public officer. So, what is the problem with this definition? If we look at it from a domestic sphere, yeah, so I identify two problems. Yeah, I hope you guys also may agree with me. Yeah, the first one can distinguish between torture and CIDPT, yeah, without giving a clear measure on how to define them, yeah. And we may also look at a Torture Convention Implementation Act 1994, in which torture is defined to include extreme form of CIDTP, yeah. And if the CIDTP do not reach the extreme form, then it become a lesser form of CIDTP and will not be covered by the protection under torture. And what is the problem with this? So the problem lies on the ambiguous measures. Yeah, when they do the differentiation and there's ambiguity into that, it will result many interrogational technique that not being considered as torture, right? And the second criticism on the definition is that perpetrator is confined to public officer. Yeah, don't you think that Rome Statute is better? Yeah, because there are circumstances in which torture can also be inflicted by non-public officer, but under the instruction or under certain connection with the public officer. All right, so for this slide, I prepared the table to assist you to understand the difference between torture and CIDTP, right? So it can be distinguished according to 4 criteria. One is severity and intensity. Second, the mental element. Third, the scope of exception. And fourth is the nature of the obligation. So if you look, for example, torture, yeah, it must be in the extreme form. Once a CIDTP reach the severity and extreme form, then it can be categorized as torture and it will be covered by torture convention. Otherwise, it remains as CIDTP, right? So, secondly, yeah, the mens rea, the mental element for torture, there must be a mental element, there must be mens rea proven. But for CIDTP, it can also include negligence. For example, prison officer failed to provide sanitation and access to medicine, which caused custodial death on the part of the detainee, for example. Yeah, and for exception, you may look at Article 2.2 of the CAT, and you will realize that the protection against torture is non-derogable. Yeah, so there will be no circumstances whatsoever will allow state to commit torture. Whereas for CIDTP, Article 2.2 is silent about it, and the nature of the obligation, you can look at Article 4 for torture, and obviously it's different than the obligation for CIDTP. Okay, let's move on. What are the state domestic obligation, in terms of the rights, freedom against torture? Under ICCPR, there's Article 2.2, which provides on state legal obligation, state party. When I say here state, it refers to state party. And if you read Article 2.2 as a whole, what it does, it assumes, on state party immediate obligation, to take to take necessary steps to ensure realization of the rights under CAT. right? That is one. And what about the nature of the obligation? So I view that the nature of obligation is negative obligation. What does it mean? It means that state shall not do anything that violate this right, this freedom against torture. Okay, let's move on. Let's look at state domestic obligation, same domestic, but under CAT. Yeah, but just now we looked at under ICCPR. Now we look under CAT itself. Yeah, so we can see here a long list on state domestic obligation. When I say state domestic obligation here, I'm making reference to state party domestic obligation, which will include Indonesia, but not Malaysia, because Malaysia is not state party to CAT, right? So what are among Indonesian state domestic obligation? One of it is Article 2.1 to take measures to prevent act of torture within the territory. And this obligation is non-derogable as provided for by Article 2.2. You may want to visit Article 2.2 afterwards. What does it mean by no exceptional circumstances whatsoever? It means that no state of war, no threat of war, no internal political instability, or not even public emergency can be an excuse for Indonesian government to inflict torture against the detainees. Yeah? And Article 4 on criminalization to make torture punishable under domestic law, and Article 10 to train police and security personnel. And you can read on your own. There's a list here. But one thing that I would like to highlight here is that only Indonesia will assume this legal obligation because Indonesia is a state party to CAT, whereas Malaysia is not a state party. Therefore, according to Article 34 of Vienna Convention, Malaysia will not assume any legal obligation because Malaysia is a third state. All right, let's move on. This is Committee Against Torture. This is the statutory body that established, not statutory body, this is treaty body. Yeah, this is treaty body that established by CAT to make sure compliance by state party, compliance by Indonesia, and the establishment is provided for in Article 17 to Article 18, and then the competency and the mandate is provided in Article 20. But I find criticism, you probably will find a lot of criticism against this body, this treaty body, in terms of the mechanism that it is empowered with. Yeah. So I put it as lack of powerful mechanism to enforce. Yeah. You can see obviously from Article 28.1, state party may choose not to recognize competence. Indonesia may choose not to recognize the competence of the Committee Against Torture. And if any individual in Indonesia were to lodge a complaint against Indonesia for violation of torture, right to torture, and the committee has to seek permission from Indonesia to initiate the investigation on the alleged violation. That is provided for in Article 20. So you decide, you think about it, whether this is a good mechanism or not, yeah, as a treaty body. So I would like also to share with you these two studies in 2009. You may pick on your own, you may read on your own, you may Google, yeah, find it in the database, Powell and Staten study 2009. Because of the high commitment placed on the state party towards the realization of the right, yeah, 81%, yeah, 81% of state party violate CAT in the same year that it ratified the convention. Show how poorly it is, yeah. And according to Amelia and Jeffrey study 2009, according to him, to make sure that this obligation under CAT is successfully implemented by the state party, the particular state party must have effective and strong legal enforcement system. So you ask yourself in your research, in your study, in your class, whether Indonesia has such effective and strong legal enforcement system. Now let's quickly move on to the state extraterritorial obligation. So we covered the proposition that Indonesia or other state party has domestic obligation. What about extraterritorial obligation? What about if Indonesia or any other state party decided to to establish a prison in another country and inflict torture, beyond the territories of Indonesia? Or maybe Indonesia or any other state party send the spy or military to go to Europe to find somebody, the victim of torture, and inflict torturers for during the investigation, and whether Indonesia, the state party, can be said that violated the obligation. The answer is yes, because state party to CAT has, in addition to domestic obligation, has extraterritorial obligation. So this is ruled by Human Rights Committee in the Lopez Burgos Uruguay case, 1981. Because the committee was saying, look, if it is not right for state to inflict torture within the domestic spheres, why can we allow state to inflict tortures outside the domestic spheres? Basically, that's how the meaning of this statement. It says that obligation is beyond state territories. It will be unconscionable to interpret Article 2 within state territory only. All right, this is some of this extraterritorial obligation. You may read up on your own as a student of law. You may pick Article 3 on CAT, on the non-refoulement principle. A state party may not expel or return or extradite any victim to the country in which torture will be inflicted on them. But at the same time, state party has a duty to extradite the perpetrator back to the country where the torture was committed, so the perpetrator can be put on trial. An effective remedy and redress, the party has obligation under Article 14 and so on. So this Fila Tiga principle, interesting case as well. I want you to read up, guys. Fila Tiga versus Pena Irala, 1980 case, is a US case, in which a torture was committed in 1978, by Pena Irala. Pena Irala was a police officer who ordered for infliction of torture against the victim, and the sister of the victim flee to US in 1978 and seek for political asylum. And so happened that Pena, the perpetrator, was present in the US. So mind you that US ratified CAT in 1994, and court in this case ordered 10.4 million, awarded 10.4 million, and court ruled that it has jurisdiction because torture is a clear violation of all national law. Although the Torturers Act was done in Paraguay, but the claim is made in the US, and both parties were present. So you must read up this case with bearing in mind on Article 14 of CAT, which provide that all state parties must provide effective remedy and redress to the victim. And the Pinochet case is relevant to Article 8 of CAT on duty of the state party to extradite the perpetrator, to the country of origin, country in which the torturous act was committed. So what happened in this case, the Pinochet was a Chilean general, overthrew president in 1973, and he committed torture and crimes against humanity, and he was arrested in London 1993. At that time, there was already many extradition applications filed against him, and UK as the state party to the CAT meet its obligation under Article 8 by arresting Pinochet and extradite him to Chile and face 200 charges in Chilean court. So I will leave you guys with this question, whether torture is justified. Yeah, for the first round, first protection, whether torture is justified. Is there any circumstances in which torture can be justified? Yeah? So please read up Public Committee Against Torture versus Israel. It was a Supreme Court of Israel. The decision is quite disturbing because it affirmed, although it affirmed that torture is prohibited under international law, but there might be instances where state authorities could engage in such practices, the so-called tickling time bomb. So this is about cases about terrorist suspect here. So for those who agree that torture can be justified, probably you want to look at theory on communitism and then theory on utilitarianism. Yeah, but for those who argue against it, yeah, so you probably can put up all these three line of argument that I listed here. All right.
I'm sorry, Professor Rohaida.
How many minutes?
Excuse me, Professor Rohaida. I'm very sorry to interrupt. I just want to say that you have 3 or 4 minutes left. I'm sorry.
Can you give me 5 minutes? Can you give me 5 minutes?
Yes.
Can you give me 5 minutes?
Yes, okay, we'll give you 5 minutes.
All right, thank you. Okay, what about right to asylum? Yeah, right to asylum. Okay, what is the sources of the protection? You can see here, okay, I already listed down the sources started with UDHR, right to leave any country, including his, and then Article 14 UDHR, you can read up on your own, and then Article 12 to ICCPR, right? Okay, who is refugee? Also, I already done you a favor in which you can read up. It is defined in Article 1A in bracket 2, Refugee Convention 1951. But what are the criteria? The criteria are already listed down here. So they must be outside the country of originality and they are well-founded fear of persecution based on 5 factors. Yeah, so you can read on your own. This is the deliberation on each of the criteria. So for refugee, they must already leave the country. But if they are not leaving the country, they still trapped in the country of origin, they will be called internally displaced person. And well-founded fear must be proven, must be established depending on the refugee status determination process that introduced or adopted by the state party. Yeah, normally, if the state is not state party to the refugee convention, the refugee status determination will be carried out by UNHCR. Yeah, and prosecution also has to be proven. Yeah, and it must be limited to 5 factors. I just want to highlight to you, think about it, whether gender persecution can be included to these 5 factors. For example, like the woman who tried to flee from genital mutilation from Africa. Yeah, they run away from Africa, they seek asylum in US, yeah? And they were granted. Yeah? This is the case of Tago in the US, right? So internally displaced person is a different, as I mentioned to you, you can read up on your own. The most important thing is that they have not crossed an internally recognized state border. Yeah, and asylum seekers and refugee, I have taken the liberty to use the position in the UK to define who are asylum seekers and refugee. Basically, according to Section 94 of the Immigration and Asylum Act of 1999, they are the one who seek asylum under Refugee Convention 1951, but their application is not yet decided by the court or their appeal is not decided by the court. Yeah, so they remain as asylum seekers, but once their application is to get refugee status is approved or their appeal is allowed by the court, and then their categorization transform into refugee. And you probably want to read up para 339C of the immigration rule. And economic migrant, a lot of people confuse between refugee and asylum seekers. to the economic migrant. So you must be careful about it. And state obligation, Refugee Convention 1951, yeah, according to, because Indonesia and Malaysia are not state party to the Refugee Convention. So by virtue of Article 34, Malaysia and Indonesia has no legal obligation except for Article 33. Why is it that? It is because Article 33 on the principle of non-refoulement is a customary international law. Yeah, so it binds a state and by the virtue of Article 38 in bracket 1D rather than 38 in bracket 1A of the Statute of ICG. And Refugee Convention, refugee status determination, I already explained to you, for countries that is not state party, UNHCR will conduct the assessment. And these are the duty to protect human rights granted to the refugee, but this duty only assumed by state party, not by Indonesia and as well by Malaysia. And refugee case study is a very interesting case. I want you to read up on this, because there's a lot of issue. There's a lot of blunder that been made by Australia, and they try to escape their legal obligation because they are state party to the Refugee Convention by entering this MOU with Malaysia. But anyhow, the court has declared that the MOU are not legally binding on both parties and is tantamount to a violation of legal obligation on the part of Australia because Australia is a state party. Okay, guys, conclusion. Okay, let me wrap up everything in terms of treaty ratification. As you can see just now, Malaysia is doing much better than Indonesia is doing much better than Malaysia. Yeah, the ambiguous measure to differentiate between torture and CIDTP is not good. Yeah, because a lot of the interrogational technique might be excluded from torture definition. Yes, state party has extraterritorial obligation under CAT. Yeah, whether torture justified, I leave it with you guys to think about it. And yes, non-refoulement principle will bind Indonesia and also in Indonesia, although both states are not state party, but it is customary international law. All right. And refugee status determination normally done by UNHCR for non-state party, and for state party, they have to assume all the duty to protect the rights of refugees. With that, I thank everyone for your attention. Thank you, Ms. Nanda.
Thank you very much, Professor Rohaida, for the very detailed presentation. It becomes interesting related to the comparison between Indonesia and Malaysia in terms of the status of ratifications of the international treaties, and about the difficulty how to define the torture at the framework of international human rights law between the CIDP and also the Convention Against Torture, and also about the refugee or the asylum seeker protection, which becomes a very important and crucial issue for both countries, Indonesia and also Malaysia, despite both countries have not ratified the Refugee Convention. So this raises concern about the obligations of both countries which have not ratified the convention, and I believe we can continue that with the Q&A session. Thank you again, Professor Rohaida. And next, I will give the time and screen to the lecturers from University Brawijaya, Ibu Ika Ningtyas and also Ibu Francisca, who will deliver a presentation on the relation between international humanitarian law and international human rights law. So I will also give you both 25 minutes, and I believe Ibu Francisca will start. I will give it to you. Thank you.
Thank you, Ms. Nanda. Let me share screen first. Okay. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Thank you for the opportunity. Actually, I will deliver this lecture with my senior, Ms. Ika Ningtyas SLM. We are from Universitas Brawijaya Malang, Indonesia, and we will deliver about the relation between the international humanitarian law and international human rights law. Both of these law is actually have human in that the name. What kind of relationship actually we have the one human in international humanitarian law and in the humanitarian law. What kind of relation and what kind of similarity we will discuss it later. So this is the today's topic. We will explain about the position of international law and the international humanitarian law, about the definition, the opponent, and the aim, the source, the international humanitarian law principle, the relation between international humanitarian law and international human rights law, the school that explain the relation between IHL and IHRL, and the conclusion. The first about the position. Actually, both of the international humanitarian law, we will call it IHL, and international human rights law, we will call it IHRL, as a both branch of international public law. So actually, both of them have a little bit interaction and intercept between IHL and IHRL itself. So what kind of actually similarities between both of the law, or maybe the different, we will talk about it later. So I will explain about the international humanitarian law. Before we go to the relationship, I will explain about international humanitarian law itself. The first about the definition. The definition development, at the first time they call it IHL is law of war, or law of armed conflict, or international humanitarian law applicable in armed conflict. It based on the definition established around 1970 within the Conference of Government Experts on the Reformation and Development in Armed Conflict on 1971. There's some of the scholars that actually want to explain what is IHL. Jean Piquet itself talked about the international humanitarian law in wide sense is constitutional legal provision, whether written and customary, ensuring respect for individual and his well-being. On the other hand, Geza Herzog stated that part of the rule of public international law, which serve as the protection of individuals in time of armed conflict. Its place is based on the norm of warfare. It is closely related to them, but must be clearly distinguished from this its purpose and spirit being different. On the other hand, Mokhtar Kusama Atmaja stated that IHL is part of law which manages protection of war victims. It is different from the law of war which governs the war itself and everything that involves how to carry out war itself. Professor Mokhtar Kusama provide actually two divisions of war of law, namely as follows: jus ad bellum and jus in bello. You can read that in ICRC 2. There are two requirements about the law of war. The first one is jus ad bellum. The second one is jus ad bello. Jus ad bellum itself is about the law governing how the state is justified in using a force. How actually the state can use the force when they want to do something. Now, that is the part of jus ad bellum. In the other hand, is jus in bello. It regulates the conduct of the parties engaged in an armed conflict. It seeks to minimize suffering in armed conflict, notably to protecting and assisting all victims of armed conflict to the greatest extent possible. So actually, jus in bello is to protect what happened after jus ad bellum or the state get attacked. So what is IHL? IHL is all provision which comprise international treaties as custom, which aim to address all humanitarian problems which arise during international and non-international armed conflict. So IHL itself actually the scope only in the armed conflict. So wherever there are some happen of rebel group happen, or what happened in Aceh or what happened in Papua, we should know that first, are there IHL could be involved in that case or not. The first one is we should know that IHL only apply in the time of armed conflict. The second one is the law restrict on humanitarian ground the right of parties to the conflict to use certain weapon and method of war, and provide the protection to the people who are victim and property affected by the armed conflict. So IHL is not only to like protect the the people itself, but also it's including how the war should be, and then how the arm we should use, and how to protect civilian object, military object, and etc. This one is the opponent of IHL, or the one who didn't contra with IHL itself. They stated that the law of the war cannot be arranged because war cannot be regulated, or war can only be abolished. The second opinion, the law of war does not need to exist because in practice it is bound to be violated. The third one, war has been abolished, so the law of war no longer exists. And the last one, because war has been as against the law, the discussion of the law of war is illegal. But actually, even until now, there's a lot of armed conflict itself. If people say there's no longer war, maybe in international aspect or international armed conflict, we still hard to see it. But in non-international armed conflict, there's still continuing happening around the world. So the aim of international humanitarian law, the first one, is providing protection for combatant and civilian from unnecessary suffering. So actually, the IHL itself not only protect the combatant who go in the first line for the conflict, but also the civilian around the conflict area. The second one is guaranteeing the fundamental human rights of those who fall into the enemy hand. The third one is combatant who fall into enemy hand must be protected and cared for and have the right to be treated as person of war. It's a little bit different than a regular prisoner. And the fourth one, preventing war currently no boundaries. Here, the most important thing is the principle of humanity. I will talk about it later. The last one is it is possible to restore a peace. And the next one is the source of international humanitarian law. I will explain it briefly because we have a lot of resource in international humanitarian law. We have like Geneva Convention 1949 and additional protocol, the Hague Convention, and the last one is the International Customary of IHL. And the Geneva Convention, or GC, we have a 4 convention, as you can see here. We have the Geneva Convention for the elimination of the condition on the world of sick in armed force in the field, and the second one in armed force at the sea. The third one is the prisoner of war. The fourth one is protection of civilian present in time of war. We have also additional protocol 1 and 2, both of them actually trying to protect the victim, but the difference is the additional protocol 1 is about the international armed conflict, or we usually call it IAC, and the additional protocol 2 is protection in the victim for non-international armed conflict, or we call it NIAC. That the difference is the two of it. There's also the Hague Convention. We have like a 13 convention, so there's a lot. It's impossible for me to explain one by one, so I will continue. This is the most important thing actually in humanitarian law of IHL, because we have like a really good principle that actually try to protect everyone in the object and the subject in the time of armed conflict. The first one is military necessity. It's talk about the expected incidental loss of civilian life, injury to civilian, and damage to civilian object is not excessive in relation to the concrete and direct military advantage anticipated in the attack. In the first picture, if you can see in the top one, is the Israel tried to bombarding the Gaza. What happened here? If you think it's a military necessity, you can think again, because in the Israel part, they said that the bombarding is used to destroy the tunnel under the ground. So the bombing itself to them is justified. And the second one is proportionality. This is prohibited attack which may be expected to cause incidental loss of civilian life, injury to civilian, damage to civilian object, or combination thereof, which will be excessive in relation to the concrete and direct military advantage anticipated. So whenever you attack, you should know who's gonna be attacked. So like if you are just attacking one village, you cannot just use the tank or nuclear. So it should be proportional. The third one is limitation of principle, how that principle trying to limit the means and method of war. So what kind of method they should use? They should use like cannot attack at night. You cannot use the nuclear weapon, something like that in under limitation principle. The fourth one is precaution. This precaution is actually including means and method which few avoiding in any event to minimizing incidental harm to civilian and civilian object. One of example also in Israel, if you are ever heard about proof knocking method, this actually the third picture. You can see here, there's a little rocket actually. It's not that big, it's a little rocket trying to like give you warning. So if you hear that small rocket in your roof, so that means you should go. That's what happened in Israel. So is it still can be justified or not? I leave it to you. The next one is humanity. Person taking no active part in the hostilities, including members of armed force who have laid down their arm, and those placed horse to combat by sickness, wound, detention, or any other causal in the circumstance be treated humanly without any adverse distinction founded on race, color, religion, or faith, sex, birth, or wealth, or any other similar criteria. So wherever they're trying to like, okay, I'm give up. One of your enemies give up. You cannot try to kill them. So that's a humanity principle. So you should protect them wherever they are surrendered, or even if they are wounded, even you are maybe medical officer from another, from the enemy, you should try to help them too. That's what humanity principle want actually. And the other one is unnecessary suffering. As the example, one is from the World War, it's about dum-dum bullet. So if the usual bullet, the wound is like this one in the left, if you see the picture in the left one, but dum-dum bullet will destroy like this. So this is created unnecessary suffering. This is the last one, the application of decision principle. You should like make a differentiation when you are attacked. Which one is armed? Which one is military object? Which one is a civilian? Which one is a civilian object? So you should make it different. And the really famous case about the distinction principle violation is Kunduz case in Afghanistan, when the MSF Trauma Hospital Kunduz got attacked by America. That's the famous one if you want to read. And the second one is, this is the Umayyad Mosque in the Aleppo, which destroyed by the ISIS, or yeah, ISIS. They are trying, actually ISIS destroy everything in Aleppo, so they never do like distinctive principle actually. So the conclusion is in the IHL, the application of IHL itself is govern the armed conflict. It should be an armed conflict. There have two separation. One is IAC and the other one is NIAC. IAC is international armed conflict and NIAC is not international armed conflict. But the difference is about the subject itself. The subject, if the subject is between two high contracting parties or state versus state, fighting against colonial domination, fighting against alien occupation, against racist regime, the exercise of their right to self-determination, it should be concluded as international armed conflict. On the other hand, if the subject itself will fight each other is state versus an armed group or armed group versus armed group in one area, in one state, it's called non-international conflict or NIAC. And if you see the last box in the slide, there's the convention actually govern each of the type of the conflict. That's all for my that's all for my presentation. My senior will continue. I'm sorry, can you hear?
Yes, we can hear you.
Yeah, that's all for my part. So I will, my senior will continue the presentation. Ms. Ika Ningtyas, that is yours. Thank you.
Thank you, Siska, for your presentation about the humanitarian law in general. Now we are going to the topics about the relation between international humanitarian law and international human rights law. Next, Siska. Okay. Actually, the closeness of human right to humanitarian law is also evident from the meaning of humanitarian or humanity itself. So that violation of humanitarian law means a same gross violation of human right. Both of international human rights law and international humanitarian law aims to protect person or individual, while the EHL particularly to protect person who are taking part in armed conflict or not taking no longer taking part in armed conflict, known as hostile combat. Hostile combats mean that combatants who are surrendered and resting from the hostilities because injury or sick. According to John Pitte, one of the most familiar scholar in international humanitarian law area, he stated that all actions are said to be good if they are based on honesty, usefulness, kindness, and clarity. Humanity is related to the feelings or mental attitude of a person shown or delivered by the person concerned as a human, or a sentiment of active goodness toward mankind. And humanitarian is description of every person in relation to humanitarian law. Humanitarian is defined philosophically as human who guarantee respect for each individual. Meanwhile, humanitarianism is universal, social or moral teaching that has good purpose for fellow human beings. So it is clearly stated that if we see from the terminology, both IHL and IHRL emphasize human as the main object. Next, Siska. IHL and IHRL are two different branches of law as described earlier. IHL and IHRL are branches of public international law. Both of them have the same objective to provide protection for human health and honor from different perspectives. Several rules are formulated in different formulations, but these rules govern the same thing, although not identical. Next, Siska. Actually, the awareness of the relationship between the IHL and IHRL was released in the late 1960s. This awareness has increased with the occurrence of various armed conflicts, especially armed conflict happen in the Africa area, to manifest the right of self-determination, which have caused problems both in terms of human rights and humanitarian law. To respond about this occurrence, the international conference organized by United Nations is held in Tehran in 1968, officially established, legalized the relationship between human rights and international humanitarian law. Thus, as a result of the conference was resolution number MU 2444 in 1968 on the respect for human rights in the armed conflict. This resolution consists of, first, the party of the armed conflict are limited in the right to use all tools to destroy their enemy. Second, a prohibition to attack civilians. And the third, to implement the distinction principle, such as the parties cannot target the civilians. That's it. Next, Siska. And there are three schools based on the Cargopoulos. There are three theories describing the relationship between the IHL and IHRL. Namely, first, integrationists. Integrationists argue that both IHL and IHRL came from one legal system. In this case, there are two possibilities. First, human rights are the basis of humanitarian law, and the sense that humanitarian law is branch of human rights. Second, international humanitarian law is the basis of human rights in the sense that human rights are part of humanitarian law. This opinion is based on the premise that humanitarian law causes before human rights. So chronologically, human rights were developed after international humanitarian law. The second view, next, Siska. The second view of the second theory is known as separatists or separatism. Separatist theories see human rights and international humanitarian law as completely unrelated legal systems because they are very different each other. The differences between the two systems lies in, we can see from the object, the nature, and the promulgation or when it comes into effect. First, from the object, international humanitarian law regulate armed conflict between states on other entities. On the other hand, human rights govern the relationship between the government and citizenship within the countries. The second about the nature, international humanitarian law mandatory has nature mandatory, political, or preemptory or imperative. In other hand, human rights is declaratory political. And the third, when it comes into effect or promulgation, international humanitarian law applies during time of war or armed conflict, or whereas human rights apply in time of peace or any times. Next, Siska. The last theory is complementary school. Actually, the complementary school, we can say it is the third way theory because it is explained about the previous theory. The complementary school that see human rights law in international humanitarian law through a gradual process develop and complete each other. Second, human rights protect persons during peacetime, while humanitarian law provide protections during times of war or armed conflict. The third, the school recognizes the existence of differences as suggested by the separate school and adds several other differences such as first, the implementation and enforcement. The second, in terms of prevention action. Actually, I will discuss about the Indonesia in term. In implementation and enforcement, and in Asia, in Asia. Actually, ASEAN, in our ASEAN region, based on the ASEAN Charter, ASEAN already has ASEAN Intergovernmental Commission on Human Rights, IHR, based on the ASEAN Charter was ratified by all the members of ASEAN 10 countries. This charter becomes the constitutional basis of the establishment of ASEAN Intergovernmental Human Rights Commission, or we known as ICHR. Particularly at ASEAN Charter, Article 14, they give a mandate to ASEAN, especially for the foreign minister, to form ASEAN Human Rights Body. Actually, the ICHR itself inaugurated at S15 ASEAN Summit on October 2009 at Thailand, but up to now, ICHR not yet saw its performance in solving human rights violation cases in Asian region. Perhaps we can see in the future, inshallah. Next, Siska. This is the main instrument of international human rights law. Next. Okay. The similarity between international humanitarian law and international human rights law. First, like IHRL instrument, international humanitarian law, such as GC and EP, impose obligation on states to guarantee the individual right to protected persons. At first, EHL only protect the person who taking part at the armed conflict, but lately, in the recent development, EHL also protected the civilians. And then the last, EHL is intended to prevent unnecessary suffering during armed conflict, and EHL content of regulation that guarantee of basic human rights described in common articles in Geneva Convention, especially in Article 3 regarding to NAYAC. Next, Siska. This picture, this chart is described about the relation between the EHRL and the IHL. Actually, there are some areas in the picture show that there are so many rights, so many basic rights is also regulated in EHRL and IHL. For example, right to life. In additional protocol 1, stated that it is requires a balance between military necessity and humanity through principle of proportionality, right to life. Okay, and then no torture or no cruel treatment. It is also stated in Article 7 on ICCPR and also Convention Against Torture, CHAT. And in other side, IHL's knows principle name unnecessary suffering. It is linear. And then no slavery. Prohibition of slavery not only stated in Article 8 ICCPR, but also stipulated at Additional Protocol 2, Article 4.2 alphabet F. That's it. That's the evidence that IHRL and EHL are related. Next, Siska. And then the differences.
I'm sorry, if we're getting yes.
Okay,
Yeah,
3 minutes, Nanda.
Okay, 3 minutes. Okay.
We're going to the end. Okay. The difference between international humanitarian law and international human law, it is described in this kind of pictures. Yeah, it's IHL in the left area and IHL in the right area. Actually, the main difference is when it is applied. IHL is applied in armed conflict situation. In other side, IHL, human rights law, is applied in any situation actually because it is applied in peaceful time and also applied in during war situation. That's it. Next, Siska. Yes. Enforcement of, next, Siska. Hello, Siska. While HLL and human rights law have developed in a separate way, some human rights treaty include provisions that come from EHL. For instance, the Convention on the Rights of the Child and its optional protocol on provision of involvement children in armed conflict in any situation or any reason. Next, Siska. Enforcement of AHL and IHL. I'm going to Indonesia case. Actually, Indonesia as the state who ratified both international human rights law instrument and international humanitarian law instrument. Indonesia already released law number 39 1999 on the human rights and law number 26 2000 on human rights court. It is one of evidence that Indonesia has strong commitment to enforcing and to handling human rights violation, something like that. Indonesia, and we can discuss it in later specifically. Next, Siska. Now, this is the end of our presentations. Conclusion. International human rights law and international humanitarian law are two legal systems that are interconnected and complementary each other. Both provide guarantee for human protection. However, the two legal systems can also be distinguished one another. There are even those who argue that when IHRL keys and IHRL come into force or vice versa. Thank you for all of the attention. This is all of our presentation, and we can continue in Q&A session, and we're giving back to the moderator. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you to Ibu Ikaning Tias and also Ibu Francisca for the presentation. It becomes interesting related to how both lecturers have applied the principles of international humanitarian law in several cases, and how there are many schools or thoughts about the relation between international humanitarian law and international human rights law, which is something that we must discuss here in the next session. So we have come to the question and answer session. I have seen in the chat box that there has many questions that have entered to both, to all lecturers actually. I will read it one by one, and I hopefully the time is here. We have approximately 30 minutes for Q&A. That's plenty of time. So first is addressed to Professor Raida. It is from Ridwan Kusdiawan from the university, from Hang Tuah University. So the question is, what efforts to protect human rights from criminal corruption that have been made by governments to prevent criminal corruption? And the second one is from Nurul Iza and also to Professor Raheda. So the question is, since Malaysia is not a party to the Convention Against Torture. So how does Malaysia curb any issues with regards to any torture or cruel treatment? And actually this second question is related to another question stated from Farhat from University Kebangsaan Malaysia. So it is related because as states, as a non-state parties to a certain convention, what is the obligation of the state? Because we take into consideration about the rule becoming customary or universally accepted to even become jus cogens. So maybe you can relate that question between Malaysia as not a party to the Convention Against Torture and the universally rule and also applied as jus cogens. And I will also give the time and question to these lecturers from Universitas Brawijaya. This is a question from Muhammad Anis from Brawijaya, stated to Ibu Ikaning Tias. The question is, philosophically speaking here, an act of waging war, from your perspective, is that part of human rights? And for Ibu Francisca, there is a question also addressed to you from Shalomita Lisara from Brawijaya University. And the question is, international human rights law regulates about armed conflicts, whether it's international or non-international. So in an armed international conflict itself, it's normalized to attack combatants, such as soldiers or civilians taking direct parts in hostilities. So does this, from your perspective, contradict from the human rights law itself? So first, for this first session, I will give the time for those questions to be addressed first. And please, I will give Professor Rahaida the chance first.
Okay, Bismillahirrahmanirrahim. Okay, the first question, Ridwan Rusniawan from University. What was to protect human rights? Was to protect
I'm sorry, Professor Rahaida. I believe there's a connection problem. We cannot hear you clearly.
Hello, Miss Nanda, can you hear me now?
Yes, we can hear you now. This is clear.
Okay, if I turn on the video, can you hear?
Okay, we can hear you now, Professor.
All right, okay. Regarding the question on the rights against corruption committed by the government official, unfortunately, we cannot see any specific rights in the core human rights treaty. But if you look at ICER, there's a provision in which Article 2.1 it put an obligation to the state party to use the available resources to ensure the realization of the rights. Yeah. So that is one. The other one, what can be done is this, I think, is under control because all state has a criminal law which criminalize corruption behavior by the state official. And the other one is that there is also an initiative under the international law. There's UNGP, United Nations General Principle on Business and Human Rights. It recognized the obligation of the state, to protect human rights in the form of being accountability, and also to conduct due diligence in whatever decision that has impact on human rights. Yeah. That is one which I can share with regard to the first question. Okay, the second question, Nurul Izzah by UKM. Malaysia is not state party to the CAT, correct? Yeah. How Malaysia curb any issue with regards to any torture, act of torture. I am pleased to share with you my personal observation is that although Malaysia is not state party to CAT, but it is doing very well. Yeah, because first, if we look at our criminal law, there's a criminalization of torturous behavior. Yeah, and the state also establishes the Enforcement Agency Integrity Commission, in which individual can lodge a complaint, yeah, against the commission of any of such misconduct, including the torturous act. Yeah? And if Nurul Izzah can look at some of the cases, yeah, some of the cases like the Kugan case in 2009, yeah, in which the court has ruled that the prison officer, the investigating officer, was committed the act of torture, and the family, yeah, because the victim died in this case, so the family has filed a civil suit to claim for damages, and the claim was successful. In addition to that, yeah, the police force also introduced the training, yeah, training of the police and investigator and whatnot. Those are the legal obligation of state party that incorporated in the Convention Against Torture. And although Malaysia is not state party, but Malaysia has done most of that. Yeah, and the other one, our Suhakam, the Commission for Human Rights, is very active, yeah, is working very hard. For example, the Suhakam is also mandated to go and visit detention center, yeah, to investigate whether there are possible torturous act that committed at any detention center. Okay, and the other question is on what you think about development of women protection in Indonesia. To what extent has been exploitation of women? Is it the question, Nanda? Miss Nanda? Is that one of the questions?
Actually, the question is from Salem Farhat, also from UKM. It's actually related. He stated that states non-parties to a treaty could be bound by its obligation if the rule becomes universally accepted and becomes jus cogens. What do you think about that, Professor?
Yes, definitely. That is the principle of law. If you look at the Vienna Convention on the law of treaties, yeah, there are certain principles that become jus cogens, yeah, jus cogens, and as well as the customary international law. So in which the principle will bind state party, although that they are not, it will bind a state, although the state is not the party to any particular treaties. Yes, yeah. Among jus cogens, you can see like a right to self-determination. Yeah, is also a jus cogens, and freedom from slavery is also jus cogens, and many other. We can go on, yeah. But non-refoulement is customary international law, and all those principles applies, and it binds state, although state are not signatory or has not ratified any particular treaties. And I want to mind you, although that I said at the beginning of my presentation, UDHR is, and I did mention, yeah, UDHR is General Assembly resolution and is a declaratory in nature. It will not bind state who voted in favor of the declaration unless they are principle of jus cogens or customary international law. And I think there's one question by Muhammad Anis Zafran. Do you want me to address that question or no?
Yes, we will give the time first for Ibu Ika Ningtyas, and then we will have a second session again with Professor Haida.
Thank you so much.
Okay, thank you. Yes, thank you. So I will give the time to Ibu Ikaning Tias and also Ibu Francisca to give feedbacks.
Okay, maybe Siska or me?
Ibu Ikaning Tias first.
Okay. Okay, thank you for the opportunity. The question is about the philosophical things about the war itself. Actually, for myself, I have my own opinion. War is the one of form of human rights violations. It must be limited because the international humanitarian law present is not to abolish the war itself, but to prevent the occurrence of cruel war. That's why ASL not regulated how war must be conducted, but stipulated two most important things. The first, about the prevent of the occurrence of necessary suffering by the others principle, limitation, proportionality, precaution, etc. And second, provide protection for those who taking part directly in the hostilities or in armed conflict, and protection for those who not taking part in hostilities known as civilian. That's why UN nation from the UN Charter itself limit very strictly about the war from the terminology of use of force. We can see in the article 41 and 42. Maybe that's all my answer, Bunanda. Thank you.
Ibu Francisca.
Okay, thank you for the question. From Salomita, if you are talking here about the human right and right to life in the armed conflict, for sure, like it could be violated if you stated like that. However, in here, like Abu Tia stated before, actually combatant itself or the person who actually fight against each other have protection itself. The protection not only when they get injured or wounded, but also the protection from prosecution. I mean, it's like what kind is in the court. If you are the soldier try to kill each other, that's okay, because you are the one who like in the front line. They have like a special protection. They cannot be suing in the court when they are trying to kill another enemy or another combatant. That's okay. So there is the special protection for the combatant itself. However, if you are talking here about the person who not taking part directly in the hostilities, they have actually the protection, the principle of distinguish between the who is the civilian, who is the combatant. So both of them actually trying to protect this the civilian itself. When they are trying to kill the combatant, for sure they're going to be get the war crime, isn't it? So if we should take a look first, who's gonna get the kill or who's the right of life get violated here. If the one who get violated is same combatant versus combatant, we cannot say that they violate the right to life, because if they get the violation of right to life and then they go to the court about what happened in the war, when they kill another army, no one wants to be the combatant. What I mean is like this protection for the combatant, if they are killed the enemy, if they are killed another combatant in the war, international conflict or non-international conflict, they're protected. They're protected and they could kill another person because in the war. However, when they try to kill a non-combatant, or if I say that a civilian or the person or combatant who forced to combat, that could be violate the IHL or can be prosecuted as the war crime criminal. That's from my perspective. If Putias want to add.
Okay, thank you for all the speakers. I believe we still have around 10 minutes, so I will open the second session for Q&A. And the next is addressed for Professor Raida. It is from Muhammad Anis from Brawijaya University. He asks about, as you stated in your presentation, about Pilar Tiga and Pena Irala, he did realize that the United States has ratified the Convention Against Torture in 1988, while the case happened before that, 1980. So is there any provisions in the convention that allows the convention to be applied retroactively? What is your opinion about that? And one more question, Professor Rahaya, is also from our students at Universitas Brawijaya, from Rivaldo. So he asks about, does a child born from a marriage between a stateless refugee and a Malaysian citizen get automatically a Malaysian citizenship status? So is the marriage between them legal under the Malaysian law? That is your two questions addressed for you. And for Ibu Ikaning Tias, there is a question from Faldo, who asks about how about legal remedies when humanitarian law is erased due to impunity for state officials or amnesty? And the last question actually is addressed to all the speakers here, from Reza Nurohman from Universitas Terbuka, which asks about the implementation of human rights ethic on military weapon and military law, such as drone killer, like in the case about the US armed drone, which killed Gen Soleimani, and scientists from Iran. So he would like to ask your perspective on that. So I will give the time now to maybe Ibu Ikaning Tias first, and then we will go to Ibu Francisca, then to Professor Rahida.
Sorry, Nanda, can you repeat again about the question?
Yes, for Ibu Ikaning Tias, the question is, how about legal remedies when humanitarian law is erased due to impunity for state officials or amnesty? So what happens if state officials become impunity? What is the remedy for this?
Okay, I would like answer in the very general term because it is very casualties. Actually, for the enforcement of international humanitarian law, we know in the national scope, regional scope, and international scope. And in the international scope, before the ICC was established, we know the ad hoc tribunal and then the hybrid court itself. And then after the ICC was established in 2002 and based on the Rome Statute, all of the human rights violation, gross human rights violation, and then war crimes, it can be solved handling by the ICC, something like that, with the certain requirements. In the national scope, as the state who ratified the several human rights law regulation and humanitarian regulation, we have obligation to ensure the enforcement those regulations by institutional and by the regulations facilitation. Indonesia already has, we have law number 39, 1999, and law number 26, 2000 about the human rights. And the regional area, even ASEAN already have ICHR, but it's not effective yet, like in the European region. That's in the term of general about the enforcement of international humanitarian law violation. For the specific case like this, like Faldo asks to me about how the legal remedies when humanitarian is erased due to impunity. Actually, impunity itself is still become a very hot discussion until now because impunity is only can, there are some principle in the international relation that state can be punished another state. That's why impunity rise. That's why state that represented by the head of government, F of the state, and in the other case, they have some accused in the gross violation of human rights or war crimes. It is very difficult to bring them to the court, especially international court like ICC, because international law itself limited the head of state can be accused by that kind of accusation, something like that, maybe, Nanda, because it is very casualties. We cannot take any similar principle or any regulation implement in this case and other case, something like that. Nanda, thank you.
Thank you very much, Bu Ikan Yes, maybe Ibu Francisca would like to add something about the drone killer in humanitarian law.
Okay. First of all, the drone killer or even the drone itself is still under, like preparation. The convention is not yet ready. So if we make a list, first, if you want to apply the application of the IHL in the case of Kian Soleimani, first of all, we should, like I always tell my students, is the first are that case is armed conflict or not. Before the application of IHL, we should know, is it armed conflict or not? If that's armed conflict, between whom? Is it US versus Iran, or like what? So if we state like that, for sure it's like US armed versus Iran armed. So we can conclude that this is international armed conflict. But until now, Iran still like keep silence, like do nothing, just complaining with the not trying to like try to attack the US. So in this case, for sure, IHL could be implemented if we can provide the fact that this is the armed conflict first. So which one is it? Ayak or Nayak? Is Ayak. So if we conclude that this is armed conflict, so IHL could be the scope of IHL could be applicable in this case. I think like that. So if which one is violate the case, it could be if that's an armed conflict when they kill each other, it's like the combatant, it cannot be classified as the war crime. But in the principle of the proportionality or precaution, they actually should give the warning first to the Iran military, give the proportionality are drone strike, just kill one person, they should use the drone strike. So there's a lot of principle that failed in this case. Yeah, that's all for me. I think if you ask that this is IHL scope, yes, it could be. But what kind of principle is filed is it could be the proportionality, it could be precaution, it could be something like that. Thank you.
Thank you, Ibu Francisca, for the answer. And now I would like to give the time to Professor Haida to give the feedbacks.
All right. Can you hear me, Ms. Nanda?
Yes, clearly.
Okay. All right. Okay. Regarding the question posted by Muhammad Anis Zafran, yeah, I think yes, he observed very well that the case was brought up before even US ratified the convention. So same goes to the Pinochet case, yeah, because the UK in that particular case ratified in 1988, yeah. I would like to answer to the question first, whether there's a clause in the CAT convention that say that the tortures convention can be applied retrospectively. Yeah? So the answer is no. Yeah? Because the beauty of the state legal obligation under the Vienna Convention is that it will only state party will only assume legal obligation when it already ratified the treaty and after the treaty already entered into force. So it will not be applicable backward. Yeah. So, but the reason why I brought up this case is to show that, yeah, if these two cases were to be applied in the current situation, in the current scenario in which US is a state party to CAT, yeah, and in Fila Tiga case, state has a duty under Article 14 to provide remedy to the victim, yeah, and for the Pinochet case, yeah, if this matter were to happen now, yeah, as a state party, the UK government has also to materialize or to meet the request for the extradition to bring back the perpetrator to the Chilean government. The request for extradition was made by Spain earlier, yeah, but eventually because of the agreement on the extradition, they decided to arrest and send Pinochet directly to Chile. Okay, let me conclude with these two cases. Yeah? Although that this case happened before CAT, but we must remember that the claimant in the Villa Tiga case brought up the case under the alien tort statute, yeah, and this alien court statute is the embodiment of the previous act of 1789, a very old act, yeah, which give federal court jurisdiction to hear lawsuit filed by non-US citizen for tort committed in violation of international law. So basically, the action was not taken under CAT, but it was taken under domestic law of the United States. Yeah, same goes to the Pinochet case. Yeah, the matter was dealt and resolved under the extradition agreement that already been established between the UK government and the requester government, which is Chile and Spain in this case. Yeah, and not under CAT, right? And yes, the answer is no. There's no provision in the CAT. Yeah. And the other question I did not really get you, Miss Nanda. Was it the question whether a marriage between a refugee and a Malaysian is being recognized and what going to happen to the child? Was it
Yes.
the question?
Yes. So,
Yes,
what
okay.
is the status of the marriage between a stateless refugee and a Malaysian citizen under the Malaysian law?
Okay, all right. But when you use the word stateless refugee, that is another categorization of refugee, because there's a stateless refugee like Myanmar, but there's also refugee that has nationality like Palestine, yeah? And Palestine and Iran, Afghanistan. We have many in Malaysia. But if they were registered, they are refugee that being registered by UNHCR, yeah, and they got married with the Malaysian. So that marriage, if were to be done under the relevant law, like for the Muslim, if they are Muslim, under the Muslim enactment, and for the non-Muslim, it will be under the Law Reform Act, Marriage and Divorce. If the marriage, the solemnization and registration is done under that law, then the marriage is recognized, is lawful. And with regard to their children, and then the provision of the federal constitution, because you must remember there's a George Sully principle, George Sanguinis principle will apply in determining the status, citizenship status of the child to that particular marriage. Yeah. So my conclusion will be, if the refugee is registered a refugee and the marriage is solemnized and done under the Malaysian law, the marriage is lawful. And in terms of the status of the citizenship of the child, that will be depending on requirement under the federal constitution. The problem is when they are not registered. If they are registered, inshallah, no problem. But when they are not registered, everything will be a problem for them. Yeah? Okay. Have I answered the question?
Yes, you answered the question very nicely, Professor Haida. But unfortunately, because of the very limited time, there are several questions that we could not address. Therefore, I would like to ask Professor Rohaida, Ibu Nintias, and also Ibu Francisca to please state your email on the chat box. So if there are any participants who would like to ask further questions privately to you, they can directly go to your email. And just for further information for the UKM side, that here at the Faculty of Law, Universitas Brawijaya, we have just this semester established a course named International Human Rights Law. So before we had Human Rights Law, but now for the international law students, we have established the course on International Human Rights Law. That's why hopefully in the next event, we can collaborate again with you, Professor Haida, and other lecturers at the UKM on this matter. So this is the end of the Q&A session. Very informative, and also I've enjoyed it very much, the lectures and also the questions. So I would like to give a special thanks for all the lecturers here, Professor Haida, Ibu Ika Nintias, and also Ibu Francisca. Very special thank you also to all the participants joining here, the lecturers and also the students from UB and UKM, and for your feedbacks for the questions and also for this session. So thank you again for the community for arranging this event. Don't forget that tomorrow we still have another joint class with UKM and also until Wednesday. So here I would like to say thank you and have a wonderful evening, everyone. I will give back the time to Ibu Mega.
Okay, thank you Ibu Nanda Saraswati, SHLLM, Ibu Profesor Dr. Haida Nurdin, Ibu Ika Nintias, SHLLM, and Ibu Francisca Yulistia, SHLLM. It's very interesting discussion. Everyone, let's give them virtual applause. Yeah, you can press the reaction below. Thank you very much. But due to the limited time, I apologize, and we couldn't accommodate all of the questions here. If some of you still have questions or wondering about something, as mentioned by Ibu Nanda, you can ask the speakers privately by email. So the speakers already sent their email address, so you can ask them directly. Well, before we end this joint class, let us take photos. I request to all of the participants here to turn on your camera again. So get ready. Our operator will take our photos. We still have 235 participants here. So excited. Yeah. We have 10 screens. Okay, once again, bye-bye to the camera or thumbs up. Thank you, Budian. Okay, everyone, I have some information for you all. Don't forget to fill in the attendance form to get the e-certificate. Please make sure you write your name and your email address correctly so that you can get the e-certificate safely. Because if you write your email address in not in the correct ways, then it will fail to send it to your email. Ladies and gentlemen, we've reached the end of this joint class. Me, myself, and all of the committee. Thank you for your very kind attention and your very kind cooperation. And don't forget, we hope to see you again in the next joint classes tomorrow and the day after tomorrow as well at the same time, 3:30 p.m. Stay healthy, stay positive, and be happy. Once again, thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. And see you.
Thank you.
Thank you again, Professor Haida.
Thank you, Professor Haida, Ibu Ika Nintias, Ibu Francisca. See you again next time.
See you. Assalamualaikum.
Waalaikumsalam.
Thank you, Nur Anissa.